After last month's sort of contract rollout overview, where we discussed what's new, the feedback that we got was that we wanted to kind of run through paragraph by paragraph to sort of see how those new bits and pieces look in the context of the contract. So here's what I have in mind for this morning. I'm going to do a combination of running you through it the way I would have the contract as talking points when I'm with a buyer writing an offer. Okay, so part of what we'll be doing will be that sort of a dialogue. And then the other part of it will be kind of stopping to highlight for our group, not what we would talk about necessarily with clients, but with our group, some of the mechanics of how the changes would work. So stop any time to interrupt me. This session will run longer than the normal hour. We'll probably run for 90 minutes because we do have a fair bit of stuff. The good news is you'll be able to replay it as many times as you want on video. Just get to live the moment over and over. So that exactly. So what I have done, my visual aids are not very exciting. They are a PDF copy of the contract. But what I have done is I've gone ahead and gone through and highlighted the areas that have either important mechanical changes or other changes or issues, restructuring that we need to be aware of. Okay, so I'm going to start with the beginning. So parts of this will be a review, but I'm going to start at the very beginning. If you're not in a dual agency transaction, make sure that the client knows paragraph 1 doesn't apply. That's only applicable if one agent is representing both parties. If it is applicable, remember for both sides you must have had a predecessor disclosure. This absolutely cannot be the first time you've discussed dual agency. Now in your listing agreements, presumably you have a pre-authorization, and this acts as the second stage consent and confirmation. If you're working with a buyer, you must have previously had a similar pre-authorization and consent. If not, it is not legal to enter into dual agency, even if the client were to consent on the spot, because the license law requires a two-stage process. When you're going through and filling out the very top part, I guess I skipped that, I do point out we want complete information, we want mailing addresses filled in, and I explain that as those are the addresses to which notices under the contract are sent. So please don't leave that blank. Because what happens if the seller's address gets left blank and it's a vacant property? Anyone? Because the contract has directions for how we handle that. Madeline is absolutely correct. The notice must be sent under the wording of the contract to the subject property address. So if no address is put in there, the notice under the contract has to go to the subject property address, which, if it is vacant, may mean that the seller will absolutely never see the notice and will miss out on it. But the notice will still be valid. So, dual agency. Offer and acceptance deadline, we move that right up to the top. So we make sure that we explain that is the overall time frame for getting the offer, any counteroffers, any negotiation, the whole deal, signed, sealed, and delivered. I strongly encourage you all to, I had an offer not very long ago come in that expired something like 4 hours after it was written. And it was a vacant property the seller had moved out of state. I mean, it was inexcusably stupid, really. There was no possible way, even if the sellers put up no resistance, that we were going to have all the signatures within that deadline, which just guaranteed we were going to shuttle documents back and forth unnecessarily. Leave plenty of extra time. Leaving 2 or 3 or 4 days to allow for the time frame needed to get the last set of signatures or initials from the out-of-state or out-of-country party to the contract does not mean that you tender the offer and the other party will sit on it for 4 days. Keep that in mind. I mean, weigh that when you're doing that. So explain that to your client. Oh, we're giving them too much time. No, that's the time frame for the whole negotiation, for the whole thing to be signed, sealed, and delivered. In paragraph 3, we're going to put in your proposed purchase price. The earnest money is written in a manner that allows it to be paid either in multiple installments, or if you're writing this offer for a client who, for example, was here this week to see houses and actually does the offer when they're back in California, you fill that out to indicate buyer has tendered $0 and will, on or before that deadline, submit the earnest money. Again, be sure you're using realistic deadlines. If you cut that too close and you don't have the earnest money in hand, you have an affirmative obligation to let the other agent and the other party to the contract know that earnest money isn't here. So be sure to use appropriate deadlines, and it can be used, of course, for two-stage. I tell buyers there is no hard and fast rule for earnest money, but in our market, 1% plus or minus is very common. It's very frustrating if you're getting an offer on a $300,000 or $400,000 or $500,000 house and there's $500 of earnest money. And it's symbolic more than substantive. So this is not part of the well, this is part of the buyer dialogue. I talk about some of this with buyers. Keep in mind, our contract has no liquidated damages clause. So if the contract terminates, it doesn't mean that the earnest money is some magical amount that gets forfeited and caps anybody's liability. It's really symbolic way more than substantive because, as we all know, in the overwhelming majority of cases where something fails to close, the earnest money is going to be refunded anyway. It really is only going to be forfeited, and even then it's not automatic. It's only going to be forfeited if the contract is terminated via default. And then even then, the disposition of the earnest money is part of the negotiations, even if there is a default. So make sure your clients know this is what's common. It really is just to send a message. It's symbolic more than substantive because if you exercise any of your contingencies and we stay within the rules and the deadlines, your earnest money will be refunded in its entirety, and the earnest money amount is applied toward your purchase price. So when you have somebody who's wanting to make some ridiculously puny earnest money amount, keep in mind what it feels like from our professional standpoint to be on the receiving end of something that just looks like it has a little more gravitas because it has a larger earnest money check attached to it. So again, the talking point there is no hard and fast rule, commonly around 1%. If you're dealing with a USDA rural development buyer or a VA buyer, I think it's much more expected that a small earnest money amount is going to be common because it's a no down payment loan program. I've highlighted a new provision here. In the event that buyers terminate this contract in accordance with its terms, sellers shall promptly execute any documents reasonably required for the release of the earnest money to buyers. And elsewhere in the contract, it actually says that any attorney's costs and court costs associated with chasing down the earnest money for release are going to be borne by that seller who's failing to sign the release. Okay? Any questions on that? Closing cost credit. This is new. This will save us from a lot of writing in margins. Okay, so that should be pretty self-explanatory. We've got all the boilerplate language to make it compatible with what lenders need to see. So insert closing cost amount here. Keep in mind, and I mentioned this in our last discussion, you really, really need to do the research on how much your lender can allow to be used. Because if you overshoot, you will lose. It's like overbidding on the showcase showdown. The stakes are very high and you will lose. Mr. and Mrs. Buyer, you can ask for the seller to pay closing costs. Keep in mind that the closing costs for lender-related closing costs are extremely low in our local market, the envy of the rest of the country. It's one of very few ways in which Champaign, Illinois is the envy of the rest of the country. But you'll commonly see lender-related closing costs that are maybe $1,200, whereas people from other markets will commonly have thousands of dollars of closing costs. Mr. and Mrs. Buyer, also keep in mind you're going to be the beneficiary of a substantial real estate tax credit that will partially offset your closing costs. So if you have the choice between inflating the purchase price to have the seller paying closing costs or not, the your cash to close is often not as great as you think. So again, I would encourage you to use, for a couple of reasons that I'll describe. Only ask for closing costs if you've run the numbers and your client, in consultation with their lender, knows they cannot get in the door of that property unless their cash to close is reduced to that absolute lowest possible amount. But the other reason to be cautious about jumping straight to a closing cost credit is because you've kind of used all your ammo if you have a post-inspection issue that comes up and you would have wanted to treat that with a closing cost credit in lieu of repairs. If you have already at this stage of the game maxed out the amount of closing costs that buyer's lender can make use of, you have no more ability to add closing costs as a post-inspection concession. That leaves you with either no post-inspection concession or having to do repairs and repairs only. Mr. and Mrs. Buyer, this is expressed in the contract as a deadline. It says on or before. Keep in mind, as long as that is a business day, that's almost certainly going to turn into the day of closing. We have to modify the contract if we're closing later because it specifies it has to be on or before that deadline, and we will only close earlier if all the parties consent to it. So barring something unusual, expect that will be your closing date. Okay, so Walt's raised a good question. If early or delayed possession is an integral part of your particular transaction, if that is really a critical portion of the landscape of your transaction, you must already be in consultation with your client's attorney so that the proposed possession agreement is tendered concurrent with the MLS contract. So in other words, we're not going to write up our own creative writing exercise and practice law without a license. So if we don't have an attorney on board helping us with this at the time we're submitting this offer, and you just submit it with the MLS form and that only, saying we're going to get this other possession agreement hammered out later, keep in mind that what you've just agreed to is that that will be possession and closing until and unless a subsequent agreement is executed. I have done that at times, and I've explained to my client, listen, I know that early possession or delayed possession is kind of important to you, or early if it's the buyer usually. I know early possession is important to you. We've already talked to the seller's agent at length. The seller is open to it. It sounds like we're in agreement on what the per diem would be. I don't expect any problems, but if you want it under contract now and it's a Friday night and we need a possession agreement from an attorney, your choices are we either wait until Monday when an attorney can get that other document ready and we submit them both at the same time so they're tied together, or we take a little leap of faith and do the MLS form right now, which gets you under contract, and we'll have to have faith that we'll subsequently come to that separate agreement to alter the possession later. If we don't, or if something changes with the seller and they won't do it, then you're stuck with this commitment. So weigh that and make sure you're advising your buyer accordingly. But I have done that when it's literally come down to we may lose the house if we wait until Monday for the attorney to get a possession agreement. This is one of a million reasons to bring attorneys in early. Have them on speed dial. Keep them at your bedside. At or before closing. So new language. Sellers shall deliver to buyers all available keys and all the following if in seller's possession: surveys, equipment and appliance warranties, subdivision covenants, conditions and restrictions, and bylaws and regulations of any association to which the premises is subject. Nothing real exciting there, but it's a good clarification. Madeline's point is a good one. The other thing to keep in mind is you may every once in a while have a house that's been where the original covenants and restrictions, let's say it's a 20-year-old house, have been passed along from homeowner to homeowner, and unbeknownst to the third homeowner in line, they've been amended in some way, and sometimes those are really important ways. So there's this obligation, but it does not in any way relieve the buyer's agent of the obligation to be diligent in trying to ascertain whether there's been any changes or find the most current. Paragraph 5, another clarification. We've never had written into it what kind of cleanliness condition it's supposed to be delivered in. And the other problem that's come up over the years is I got in the habit of trying to proactively do this, but how many of us have had somebody who had a 1955 era Jeffrey Dahmer body-sized chest freezer in the basement that obviously had been in that house for the last 14 owners because nobody wanted to have to deal with hauling that out? And so the seller figures, well, I assume that could stay because I let it stay when I bought it and the person before me did, and the buyer does the final walkthrough and says, I don't want that stupid thing there in the house. But there's nothing in the old contract that said, nuh-uh. So anyway, now the default setting is if it's not listed in the personal property, it needs to be hauled away. Broom clean, so now we have something that talks about the cleanliness standard. Now instead of having no standard, we can argue about what is or is not broom clean. So it's not going to solve all of life's problems, but it at least creates some sense of you don't have to repaint all the walls, replace the carpet, or necessarily professionally clean the carpet, but it is not going to be covered in filth. So be aware that it's in there. I would still suggest if you know that something's particularly important, putting it in writing is always the best way to go. I don't think this is of such insignificant value. I don't think it's likely to be of concern to a lender. If it is, I don't think it's going to get taken out of the property anyway. Paragraph 5A, 1 and 2 are identical to how they've always been. So Mr. and Mrs. Buyer, paragraph 5A says that buyers acknowledge they've inspected the real estate and the improvements thereon, and they're acquainted with the condition thereof. That is not referring to a professional home inspection. Mr. and Mrs. Buyer, what that is saying is you have been to that property and you've seen it with your own eyeballs. This is an important way to lay the groundwork for setting realistic expectations. Mr. and Mrs. Buyer, you've seen it with your own eyeballs, you've inspected it, you generally know the type of condition of the property, and you're agreeing to take it in, and 5A1 is as is period as it's always been. 5A2 is the more common as is condition with the typical seller warranties. Please understand, Mr. and Mrs. Buyer, normal working condition doesn't mean new and it doesn't mean perfect. It means normal working. So be realistic in terms of what you expect out of the property. I want to also pause and point out, every once in a while you'll have a seller, for example, who really is insisting on, no, I'm only selling it as is, I'm only selling it as is, especially if it's an estate, something like that. Only selling it as is. And then you get agents on the other side who are freaking out because I'm not going to not have my seller warranties, I'm not going to not have my 5A2 warranties. Well, guess what as-is condition means? Does it really mean that the property can be a smoldering heap of rubble when you do your final walkthrough and you still got to close on it? No. As is, as of when?
Date of the signed contract.
As is, as of the date of execution of the contract. So if the property was not a smoldering heap of rubble when you signed the contract to purchase it, it is not permissible for it to be a smoldering heap of rubble at the final walkthrough at the closing. So as is does not literally mean that you are stuck with whatever condition you find it in when you close. Now you would find something closer to that language in a typical REO contract. As is, where is, no warranties. However you find it at closing, you're stuck with it. But our contract, just keep that in mind if you ever get into a power struggle. It's not that big a deal. And especially if it's as is and you still have a home inspection contingency. And then the inspection report acts as a way to sort of memorialize what that condition was in. So there again, if the furnace worked at the inspection and it doesn't at the final walkthrough, it's not in the as-is condition it was in when they signed the contract. So just something to keep in mind if you ever run into somebody you're butting heads with because they're insistent on as-is and you got a client that's freaking out over it. Home warranty, same as always. Final walkthrough, same as always. So it is not required, the three-prong outlet's not served by a ground wire, so it is qualified. So in other words, if it is a modern house, something built in the last 20, 30, 35 years, where it's got modern Romex wiring that has a ground conductor in it, if that's the kind of wiring that's present, it does have to have a working ground. It qualifies it by saying, not served by a ground wire. So in other words, if it's a knob and tube or one of the mid-century two-conductor wired houses with the cloth kind of insulation. So if it is that age house and the wiring still does not, at the time was installed such that normal working condition did not include a ground, the mere fact that somebody in the last 40 years, after it had been hit with 14 layers of paint, swapped out an old two-prong outlet with a three-prong does not a 5A2 warranty violation make. It does not keep you from citing that as an unacceptable deficiency in the home inspection contingency. So it can still be brought up if it really is a surprise. Every once in a while we'll have a buyer who says, oh no, that really is critical for me because I operate a whole bunch of elaborate computer equipment. Or some of my amphetamine manufacturing gear requires a working ground and this is not going to work for me. There's lots of important considerations here. So that's a good point. But I guess with the attorneys, this is a hot button for the attorneys. The attorneys themselves got sick and tired of seeing post-inspection and or 5A2 requests saying, open ground, open ground, open ground. It's a 40-year-old house that never has been grounded, and so we're not going to nitpick over that. The inspectors are pretty good about it. That's an example of where in the report, they have to note it in a way that sounds like a fundamental defect and sounds like it may kill you and your loved ones. But the good inspectors, and this is really an important differentiating factor between the really good ones and the not as good ones. The good ones may have somewhat scary-looking written reports. Their standard of practice governs how they have to note items. But the good ones will say when they're talking to the client, here's the deal. You just can't have it appear to be grounded and not. A label solves that problem. Getting out a label maker solves the problem. Or switch it back to a two-prong. Label maker is easier because you got things like Dell notebook computer adapters, for example, that have three prongs on the plug that don't actually need an equipment ground, but they won't plug in. They won't physically go in the plug if you don't have one that's got three prongs. So the label at least makes clear that somebody who is plugging in whatever equipment is that has to be grounded will know when they go to that three-prong plug that it doesn't have a ground. Okay, Mr. and Ms. Buyer, we're going to have the opportunity to do a final walkthrough during the 48-hour period prior to closing. Disclosures, you're acknowledging that hasn't changed. Receipt of these various disclosures. Professional inspection, this has changed a fair bit. So buyers may at buyer's expense have a whole house and or any component thereof inspected. And there's several changes in here. By a licensed whole house inspector and or a contractor licensed to service the specific components being inspected. I had a licensed roofer perform a whole house inspection illegally on a property last year. Pretty nice property. It was almost $300,000. The licensed roofer, who was not licensed to look at anything else in the house, but who went ahead and took the liberty of doing a whole house inspection report anyway, guess what his conclusion was? It needs a new roof! So who could have guessed it? And it didn't, as it turns out, but it raised all sorts of hell because then you have to talk a buyer off a ledge. Once their expert has told them it needs a new roof, you need about 50 others that say, no, it doesn't, before they'll believe you. So this helps tighten up the standards for who can inspect what. So If you're bringing over a specialist, so if, for example, you don't intend, because some of us will have savvy buyers who say, you know what, I bought and sold houses before. I do not need to pay for the whole house home inspection. I'm going to sweeten the deal by making it a little more as is. The only thing I need to have inspected is I'm going to have a roofer visit to look specifically at the roof. Or I'm going to bring over an electrician because I have a specific electrical issue I want to double check. Okay, so just be aware of what the ramifications are of that. But you can't, under the inspection contingency now, bring over somebody who is not duly licensed for the component being inspected. The mechanics of how this works are going to be, notice that if the report or inspector of a licensed contractor notes deficiencies which are not covered by 5A2 above. Now let me pause for a second there. 5A2 is already covered elsewhere. Normal working condition, not new, not perfect, normal working. I would still tell you include your 5A2 defects in the post-inspection notice as a practical matter. So the wording is that way to parse them out. I would still throw them in there. If you don't, here's the danger. You serve a separate 5A2 notice, which first of all means you're serving two sets of notices if there's going to be some 5D and some 5A2 stuff. So that's one complication. Secondly, even though there's an absolute obligation to deliver those major mechanical systems under 5A2 in normal working condition, that does not mean you will not get into an argument that will last all day long over whether it is or isn't normal working condition. And so by throwing that in, if your buyer knows, as far as I'm concerned, it's unacceptable, and the seller would be inclined to argue, well, but it's still normal working, go ahead and treat it under 5D. Everyone got that? So even though it does say not already covered under 5A2, that doesn't mean you necessarily have to do two separate notices. I would still go ahead and throw those into the 5D notice. If you're only serving a 5A2 notice, don't use the post-inspection form. Okay?
What do you use?
You just have to send a letter. But remember, the big reason that we get worked up over the post-inspection protocols are we got deadlines that if you miss them, you've waived your inspection contingency, so the stakes are really high. The 5A2 warranties run all the way till closing, so you can be much more informal there because there's no issue of we got to prove that the notice was properly, validly served by a certain date. If the other agent says I didn't get it the next week, you can bring those items up all the way at closing. I will commonly write the notices, but I will only do it if I already have an attorney on board on my side and the attorney approves it.
Right.
And I use it as part of my commercial for why the buyers need to have an attorney. Mr. and Mrs. Buyer, I am happy to do as much of the legwork for you as possible, including helping you draft post-inspection and or 5A2 notices. However, I am not an attorney, and I'm not going to draft legal notices under this contract if you don't have an attorney who can review it. In other words, your getting an attorney will let me do my job better. Okay, so you notify under Roman numeral 1, notify sellers with a written notice of deficiencies in post-inspection amendment accompanied by a copy of the written inspection report that buyers are terminating the contract. Aha! That's a difference. So one option now is just cut to the chase. We're serving a notice, not trumping up a list of everything in the inspection report so we can go through this stupid charade of the buyer wants out because the inspection has taken the wind out of their sails. And so the only way under the old deal for them to get out, serve a notice that was filled with so many requests, loaded up like a Christmas tree, there was no possible way the seller would agree to it. Then you wait the seller out, and then the post-inspection agreement deadline comes and goes, and then and only then is the contract terminated. If you know after the home inspection the buyer says, I don't want it anymore, the contract now very explicitly gives the buyer the right to send a notice that says, I don't want it anymore. And the post-inspection notice/agreement document provides for that. Or Roman numeral 2 is very similar to the old language. Notify sellers of all unacceptable deficiencies which buyers require to be repaired in a reasonable and workmanlike manner, and notify sellers of all unacceptable deficiencies for which buyers require a credit in lieu of repairs and the amount of the credit required. We're talking buyer talking points. On the flip side of this, we need to make sure sellers know when they accept that offer, hey, until the inspection contingency comes and goes, don't make any plans you can't get out of. Because there's always a chance, and there always has been, but this makes it a little more explicit. There's always a chance that the buyer pulls the plug on the whole deal, and there won't be a darn thing you can do to stop them if that's the road they choose to take. If repairs or credits are agreed upon, all unacceptable deficiencies shall thereby be resolved, and the warranties in paragraph 5A2 will no longer apply to conditions noted in the inspection report. From the sounds of the room, that is not exciting all of you as much as it excites me. This is my idea of a good time. What this is you remember those miserably confusing multiple choice options for the continuation of 5A2? I'm getting a lot of looks like, Difanis, your fantasy life is very sad. Anyway, those terrible multiple choice options that nobody seemed to understand. This is choosing the more sensible option and dispensing with the multiple choice that caused me to get phone calls from everybody all the time, especially on Friday and Saturday nights after 8 p.m. Which option do I check? I don't know. I'm conflicted. So now let me explain what the ramification is. The old form basically would give you the option of saying that the 5A2 warranties are going to apply to everything in the inspection report except items for which a repair or credit has been specified. That option, this wasn't the attorney's intention, but the way the option could work is buyer has an inspection. The inspection reveals certain defects. Those defects include an exciting variety of 5A2 and non-5A2 items. The buyer, having been made aware of an exciting variety of 5A2 and non-5A2 items, decides which items they want to cite as unacceptable. They then enter into post-inspection negotiations, at the end of which they end up with a shiny post-inspection agreement. But under that option for the continuation of 5A2, the buyer could have made a calculated decision at that time. I'm not hitting the seller up for every stupid little thing like the threads at the bottom of the TPR overflow extension pipe as a 50-cent example. I'm not going to hit them up for that. I'm going to only deal with the bigger dollar items. And yet, under that old language of the continuation of 5A2, you could have a buyer who then waits to spring that on the seller at the closing and say, never mind the fact that I had an inspection 4 weeks ago and I knew about it ever since then. I have still reserved the right to bring all that little petty 5A2 stuff up and throw it at you right now. That was not ever the intention, but it was the way it could operate. And so the attorneys finally capitulated and said, fine, we agree. This will basically be the only option. We're baking this in, so if it's in the inspection report, it's no longer covered by 5A2. In other words, any defects that you don't choose to bake into your post-inspection agreement, any 5A2 defects that showed up in the inspection report are off limits thereafter. If the parties do not come to a written agreement regarding the inspection results or complete paragraph 5E below, on or before blank, the agreement deadline, the buyers have not withdrawn the notice of deficiencies or terminated the contract. Let me pause. Another new and exciting option. It's the I'm so sorry, I take it all back option. Because it says buyers have not withdrawn the notice of deficiencies. We didn't used to have that option. So once you rang that bell and served a notice, there was no taking it back. And so let me give you an example. And Jeffrey and I have something like this going on this week. Actually, we have 2 of them going on this week. You have a seller that signs a contract, and then 2 seconds after they've signed the contract, you have another agent that says, what, that just sold? I have clients who would have paid full price for that. So you never know on the buyer's side when the seller, either justifiably or just because they are imagining it, think that they could have gotten a better deal, or think they don't want to sell after all and just got cold feet. And then the buyer decides, you know what, I think I'm going to hit them up for a bunch of relatively nitpicky home inspection stuff because I'm bored and it sounds like it would be a good time. Well, if you've miscalculated and that seller was just looking for an opportunity to bail out of that deal with your buyer so they could sell to the other buyer that's waiting in the wings, or because they changed their minds, you're screwed. Under the old deal, you had no possible way to unring the bell. Once you served the notice and it was out of the gate, all the seller had to do was refuse to sign any post-inspection agreement, contract terminated, your buyer lost. And in some cases, your buyer lost because your buyer stupidly asked for the one fogged window. You asked for one silly, kind of petty, really screamingly obvious item that you could have seen during your showing, and that cost them the house. So now, if you happen to have that buyer going forward, they can be stupid, but they can take it back, as long as they take it back according to the deadline. So be aware of that. And the post-inspection notice and agreement provides for that. We wanted, on the realtor side of the contract working group, we kind of wanted the idea of a multiple choice checkable list of inspection contingencies. And the attorneys politely shot that down, saying, we don't like the idea that a buyer at 7 o'clock on a Friday night writing their offer without the advice of counsel is going to box themselves in terms of what inspections they can or cannot have. And I think that's a fair point. So what we then chose to do, and the attorneys agreed, because Richard Joy loved the fact that his inspection language was sufficiently broad that it would be all-encompassing for any inspection you want to do. Well, that's great, Richard. If it goes to court and gets litigated, I'm sure you're right. The problem is you have sellers who say, I didn't see anything in that contract that said they could test for radon, mold, asbestos, lead. any of those sorts of things. And so we now have new verbiage here that says, here's the laundry list of things that you're agreeing that this inspection contingency could include. And it also saves us another step. Where such inspections require that the test equipment be placed on the premises, radon, sellers agree to permit reasonable access to the premises and not to tamper with the test equipment. So now there shouldn't be any issue of sellers dragging their feet to not give consent. So Nick's question is, how do you deal with a high radon deal? And I know that at least one other firm in town has started using a standard amendment that's not an MLS amendment. And I already shot it down when it came to us because it sought to pin 100% of the cost of mitigation on the seller. Radon gets treated, and really always has, just like any other unacceptable deficiency. You put it in the list with everything else, and the parties negotiate for a mutually acceptable agreement. Normally, commonly, that's going to be splitting it. It's rarely going to be that the sellers pay for all of it. And here's why. And this goes back to setting realistic expectations for the buyers. Here's why. Mr. and Mrs. Buyer, by the time you learn that the property you're going to purchase has high radon, you will have paid $350 to $400 for your home inspection. You will have paid another $150 for your radon inspection, so you're up to $500. Depending on the time of year, you may be on the hook for another $300 for your appraisal that's already been done. You may be $800 of sunk costs into this transaction, and you may have waited 3 or 4 weeks, depending on the inspector availability, to find all of this out. And if it tests high and it's going to be mitigated, guess who's going to get 100% of the benefit of the low nuke zone that's going to be present in this house going forward? You, not the seller. So from a purely pragmatic economic analysis standpoint, if the offer on the table is, tell you what, we're going to split it, does it really make economic sense over a $1,200 total radon mitigation bill for the buyer to walk away, lose $800 in sunk costs because they wouldn't agree to pay for $600 of half of the radon mitigation? And I'm not saying that rule applies across the board. All bets are off. The parties get to negotiate it. But that's a quick analysis of why it makes sense usually to do half when you think of the amount of sunk costs as a backdrop. The other deal is you may have a seller who you know they're perilously close to the absolute bottom dollar they could possibly afford. They may be covering a deficit at closing, and if it's another $1,000, they literally won't be able to make it through the closing. And so that's another reason why radon should go in the mix with everything else, because if you bake in up front, no ifs, ands, or buts, if it tests high, seller's on the hook for every penny of it. Now, the seller half of the analysis I went through earlier is the seller has a potent incentive to do something with that buyer right then to pay for part of it, because obviously if that buyer walks, the seller has a legal obligation to update the seller's disclosures, say, yes, I am aware of radon, and at that point the next buyer won't get $800 into it before they find out the radon is high. The next buyer will know before they ever make their offer, and the seller is then, with any future buyer, guaranteed to have to pay 100% of it. So, I mean, that unique set of circumstances, when it comes up with the buyer that you have right there at that moment, that's why splitting it often makes sense, but you don't want to get a seller committed because that $1,000 could pay for a lot of other miscellaneous repairs, but if it tests high, I can't do this and that stuff. So put it all in the same mix. I discourage you from trying to pre-bake a solution to the radon issue if it comes up. I also will tell my sellers, maybe 2/3 of buyers test, and it's almost exactly 50-50 in terms of the houses that test high, and there's no rhyme or reason to it. There's countless examples of houses next door to each other or across the street from each other where one is crazy high and one is crazy low. So in the post-inspection agreement, you would put something like the following under repairs. Sellers shall have a radon mitigation system installed by a licensed contractor with guaranteed post-mitigation results. I mean, if you want to be really specific, because they could be licensed but still not have a warranty. So again, sample language, seller shall have radon mitigation system installed by a licensed contractor with guaranteed post-mitigation results, or you might even put with a guarantee of not less than 6 months, for example. The cost of which shall be split evenly between the parties at closing. Or I had one recently where the buyers just agreed they would be on the hook for a flat $500 before we knew what the amount is. The cost of which shall be split as follows. Buyers shall pay for $500 and any balance shall be paid by sellers, that sort of thing. Okay? Check with your lender. Madeline's question is, do you need to do post-mitigation testing? Here's the problem with post-mitigation testing. Do you know how much it costs to test radon in your own house?
$30.
About $25 or $30. Do you know why it is that we have to spend $150 to test it with an inspection? I think everything I just heard, all the murmurs I just heard were correct. In a nutshell, the reason is if you're testing your own house, you're going to maintain your closed house testing conditions. So you can go buy or mail order a $20 testing kit that you put out in your house in the right location for X number of days and then mail it away for the test results. And you maintain your own closed house conditions. If you are testing a house that you don't own and the premises are not premises over which you have physical control or custody, then the only way to know that the results are valid is to have testing equipment that, number one, samples very frequently so that you can get a valid result with as little as 48 hours or 24 hours, whatever the shortest is. But I mean short frequency, short duration, 48. So it has to be expensive gear that samples very, very frequently, but it also then has to be expensive gear that samples a whole bunch of other environmental variables so it will throw a flag if someone's opening the window or turning on a massive exhaust fan. That's the reason it's so expensive. So answering Madeline's question, if a lender isn't going to demand that there be post-mitigation testing, and you've gotten remember I suggested, a warranty of not less than 6 months, then something that will cost another $150, $160 and create a whole other scheduling hassle and logistics hassle and access to the house and closed house conditions all over again, which may be happening while somebody is moving all of their earthly possessions out of that house. So in other words, it's impossible. All of that can be eliminated if you wait till after closing, you know it's warranted, and you buy a $25 test kit to make sure that, in fact, the results were achieved. So check with your lender, because you can't always count on that, because every once in a while you'll get a lender who says, oh no, we won't let it close if we see that there's a radon mitigation system being paid for, unless we have follow-up test results on file. Anyone have any other questions on that? That was a really long answer to Madeline's question. I apologize.
Post-mitigation method. The buyer pay for that?
That's all open for negotiation, but it's it's just when you're talking another $150 for something that could cost $25 if you did it the next month when you're in the house yourself. That's why I'm hesitant to just throw it in there. This stuff piles up very quickly. All right, so paragraph 5E, this is new and exciting. Post-inspection closing cost credit. All right, so our old post-inspection agreement had two options, repairs and credits. And how many lenders will allow you to just have a generalized repair credit? None. So we had an MLS form that was in circulation for years when one of the commonly requested options was completely unworkable. And so what we were having to do on a case-by-case basis was do this really convoluted reference to a credit amount in the post-inspection agreement, further indicating that instead of a repair credit, a credit of that same amount was going to be applied as a closing cost credit and was going to be added to the face of the contract. So you had a whole musical documents deal, and it required then writing the closing cost credit in the margin of the contract. So you still have to basically do all of those pieces, but there is now a pre-printed written framework for doing it. So you'll see the closing cost credit option in the post-inspection agreement. Here's where it shows up in the contract. Note that this is paragraph 5E. We earlier talked about a closing cost credit on page 1 of the contract. That would be used if you know you're requesting a closing cost credit with your initial offer. Paragraph 5E is specifically for a post-inspection closing cost, and note what it does. With the exception of repairs required by a post-inspection amendment or a repair amendment, if any has been executed by the parties, buyers accept all conditions noted in the inspection report as is. So you get what that's doing? The reason for that language is by initialing there, the parties are agreeing that the inspection contingency has now gone away. Everything is as is because the whole reason you're initialing is you're getting money to take those things as is. And you can still do a combination of repairs and credits because it carves out if there's other repairs that have been agreed on. One at a time. Questions?
When you initial 3B, you also have to reinitial paragraph 1.
Yes, absolutely. So Chuck made a good point. Post-inspection agreement, I think, also makes this point as well. Anytime you make a change, and I said this in the business meeting yesterday, you also need to update your offer and acceptance deadline. Because what's happening is that after the fact change is basically an amendment to the contract. It's a change in the terms of the contract. It basically means you had the final buzzer earlier on the negotiations, but you then went into overtime later after the inspection. And if you have not updated the offer and acceptance deadline, you will have had a new set of initials affixed to that contract that went on after the offer and acceptance deadline, thereby rendering the contract void on its face.
So in theory, we could update that offer and acceptance deadline multiple times.
And I still, on my team, and I encourage everyone to do that, when a lender kicks something back and says this needs change, that needs change, drive needs to be added to the address, any of those things, always putting an extension to the offer and acceptance deadline.
Bigger blank there.
Huh? Need a bigger blank? Yes. Yes. Okay, we're going to cruise through a bunch of this because nothing has changed here. So this is all standard verbiage, deed of conveyance. Mr. and Mrs. Buyer, this is the instrument that transfers title to you. It's the seller's attorney that's going to do that. Another opportunity for buyer attorney commercial. They will consult with your attorney as to the best, most favorable manner in which you should take title to the property. Taxes, assessments, and notices. This is where you're going to want to have the conversation about how the real estate tax credits work. So I encourage you to have a dialogue for that. We can discuss that on a different day because we want to cruise through this. Insurance and risk of loss, which still has language regarding an endorsement for contract of sale that no insurance carrier is actually willing to produce. Evidence of title. Condominium hasn't changed. It's changed a tiny bit. We have, in the event the property to be sold here under is a common interest community association, sellers upon demand make a diligent good faith effort to make available to buyers all disclosures, but no major changes there. Wood infestation report has one sentence here. If there's a termite treatment necessitated because of an active infestation, treatment shall not be by in-ground or similar bait system without buyer's consent. Again, this was an attorney-driven change. But at least one attorney's opinion is, and this explanation is probably not even from one of the ones on the contract working group. His take on the bait system is there's a treatment option where you do it once and it kills the insects and it keeps them from coming back for quite a long time. Or you can undertake a more expensive treatment option that will cost more money up front, obligate you to ongoing regular expenditures into the indefinite future, and really appears mostly designed to make the insects angry. So, with that explanation, the idea is you as the buyer do not want the seller to have the prerogative to choose the make the insects angry option that will also, incidentally, cost you more money going forward. And therefore, the default setting for termite treatment is going to be a drill and fill type of treatment unless the parties agree that they're going to allow a bait system instead. Lender required inspections hasn't changed. Default hasn't changed meaningfully. Notices. The mechanics of the notices paragraph has not changed at all. Not one bit. This is a clarification. It is not a fundamental change in the way the paragraph was ever intended to operate. It's just really explicit. Notice, the scope of a realtor's agency does not include the authority to bind any party nor to amend any terms of agreement, and notice by or to a realtor is not effective as to either party. It already had said notice required under the contract is to be served upon sellers or buyers in writing, so it already had all the instructions we needed, but this just makes very explicitly clear realtor to realtor notice is no notice at all. Okay? Follow the instructions in there, especially if you're on a deadline. 16 hasn't changed. 17 is largely unchanged. We still have our 7-day dance on paragraph 18. However, 18 does have a couple of exciting options, a couple of exciting updates. We had no real qualification for what a financing commitment was. And that was a problem. So this is a little more specific. So obtain such a commitment conditional only upon maintenance of the status quo and other matters within the buyer's control. So you'd get this pre-approval, then you'd get a conditional approval, and the conditions could range from any number of things. And the idea is it's not an approval under this contract unless it's approved for everything having to do with the buyer's creditworthiness, subject only to the buyer not screwing anything up by buying a new Maserati on credit. And further, let's just say the buyer, let's take that example a little further. Let's say the buyer bought the new Maserati and didn't buy it on credit. Then they may trigger the next part that's exciting changes. Non-availability of funds, i.e. I used to have a lot of money for my down payment and now I have a new Maserati that I paid cash for. Their non-availability of funds at closing shall not be a valid basis. So technically under the old contract, if the buyer's money had gone missing, new Maserati in the driveway, a really fun trip to the riverboat at Peoria, whatever, the lender says, well, I'm not going to close it. Well, you make the lender the bad guy, even though it was the buyer's own stupid choice that rendered the buyer unable to get the financing. This makes this clearer. The buyer does not get to say, I'm bailing under my financing contingency and I get my earnest money back if I scuttled my own financing by dissipating my down payment funds. Nick and I have one going right now that would have gone a bit differently if this paragraph existed, because we had a buyer who was pulling down payment funds out of a qualified retirement account and didn't realize that was a long, involved process, and the closing's gotten way delayed. In situations like that, this would cause some serious problems for the buyer. As it should, because it's not the seller's fault in those cases. Personal property hasn't changed. I've added a little more space for it. All other personal property shall be removed from the premises unless otherwise agreed by the buyers. Sellers shall specify above if water softener, propane tank, or other installed equipment is leased or owned by a supplier rather than the sellers, and the parties shall prorate applicable rent as of the date of closing. That just kind of cleans up some housekeeping matters that had not been explicitly addressed in the previous revision. So none of this has changed. So the rest of this is the same. Okay, and we're going to jump to the post-inspection agreement form and notice form. All right, so here's the new post-inspection form. All right, so the old post-inspection form really was not designed to be a notice. It was designed to memorialize the ensuing agreement, but it wasn't designed to be the notice. Realtors would use it as the notice, and even Richard Joy, who I could swear when I was there in 1999 when he did the orientation of the last contract, had said it was not intended to be the notice, but by a dozen years later he had said seemed to think he had intended it to be. But it wasn't really set up for it. This makes it much clearer. This document is intended to give us an MLS form framework for the notice and the agreement. So you are absolutely not only encouraged but really required, unless you're getting something custom drafted with input from an attorney, to use this. So the first part is the notice part. Pursuant to paragraph 5D, the buyers of the premises located at fill-in address here have presented the sellers with an inspection report, and then you check the box for deficiencies and you write out all of what is unacceptable. I tried to provide a pretty good amount of space there, and that all wraps and is spaced appropriately as you fill it in. Be very clear if you're going to reference an attached exhibit, for example, the repairs recommended summary of an inspection report. That's okay. But be very, very clear, because some examples of not clear are the highlighted items in the attached inspection report, which I highlighted in dark pink and then scanned in a black and white scanner, for example. Or which I highlighted in very, very light yellow and scanned in a black and white scanner, for example. So if you're going to do this, be very, very clear, and just say if there's too much stuff to repeat here. If it's a short list, don't be lazy. Actually write it in. Write in what the item itself was, because it's easier that way. But if you have a long laundry list, and you often will, you can indicate the following numbered items as they appear in the repairs recommended summary section of the master spec inspection report, comma, dated, fill in date, a copy of which is attached hereto. But if you're going to start referencing some external document, and as an example, we know in some cases we got two versions of an inspection report that were issued the same day. It needs to be really, really clear. Don't reference it and not attach it, because we know that numerous inspectors will send an electronic copy with the photos embedded. Photos weren't embedded in the copy they printed on site. Or, as you're leaving, you'll mention, oh, what about this? And they'll add it. And what does that do to the numbering? It shifts it all around. So just keep all of that in mind. You know, we all in this office are pretty highly productive, so we all know what that's like if you realize, oh, wait a minute, I don't know which version and which number that actually applies to. So if you're going to reference an external document, the following numbered items as they appear and you name exactly what it's called. Different inspectors use different terms: repaired recommended, repairs needed, one that I don't particularly like because it's not clear, the marginal summary, i.e. nothing in this summary is a big deal, but I'm going to ask for all of it anyway. But anyway, be really clear what you're asking for and reference it by date and attach it. Brad? That point is very good, and be sure then if you're referencing the numbers, put parenthetically, after you put item 3, put parenthetically both the cleaning, like in one I just had, item 3 with Autumn. Item 3 included both threads at the bottom of a TPR overflow valve, and in the same numbered item, it was overdue for cleaning and servicing. Right. And in fact, it caused confusion. So be sure parenthetically to indicate both the threaded pipe and the cleaning and servicing. So the fix, going to Brad's point about if the inspector had referenced a qualified structural engineering opinion is recommended, you can indicate what the repair or the credit is going to be for, and then the repair indicate. Be cautious. Don't carelessly throw in terms like licensed contractor. The inspector always will use that term. They're constrained by their standards of practice. If you're on the seller side and buyer's agent does that to you, be sure you discuss that with the seller. Because we all know, in fact, one of them has his trailer parked outside right now, but we all know contractors who are very, very capable of a wide variety of repairs. They may not be super specialists, but most of these post-inspection lists don't have super specialized stuff. So just be careful not to get yourself boxed in by having your seller agree to have everything done by a licensed contractor. Okay? So you check repairs and then describe the repairs. This is just like the repair amendment, the boilerplate language. And keep in mind, people forget there is boilerplate language, but that means something, and it affects how you should write the repairs. The seller shall repair in a reasonable and workmanlike manner on or before the date of possession the following conditions. It already says it's going to be reasonable and workmanlike. That's already specified for everything you put in. So if it doesn't truly have to be done by a licensed contractor, and sometimes it may. Sometimes it may be something where the seller fixed it themselves 4 times, and they obviously needed a licensed contractor. So, there may be instances where you very deliberately want to make that clear. But keep in mind, it already specifies a standard for the repairs if you just itemize what the repair is. But going back to Brad's point, be sure you're clear if item 6 included the threads on the TPR valve overflow pipe, as well as cleaning and servicing. Be sure both are clear. This language is the way it has always been in our post-inspection agreement and repair amendment. Price reduction, this is new. So we have totally reworked the way that repair credits work. In lieu of repairs to the unacceptable deficiencies for which no repair is specified above. The reason we have it done that way is these are not mutually exclusive. We have many instances where we need a credit for some of it and repairs for others. So you can still do both, which is why it's worded that way. The sellers hereby agree to, option 1, reduce the purchase price. That's fine. It often isn't the desired outcome because it doesn't put dollar for dollar back in the buyer's pocket. And if you do this option and there is a lender, be sure the lender gets the updated contract. Speaking of somebody who failed to give the lender the updated contract not too many days ago on one of these. Option number 2, allow buyers at closing a credit toward, and this was fairly complex, toward buyers' prepaid expenses and settlement charges as described in the HUD-1 settlement statement in the amount of blank, or such lesser amount as is permitted by buyer's lender. At the request of either party, the party shall execute a new residential sales contract or an amended version of the current residential sales contract to reflect this credit by initialing paragraph 5E and completing paragraph 3B. 3B being the closing cost credit provision in the contract, and 5E being the initial here to indicate that we're going to do a closing cost credit in consideration of the inspection items being as is. Consult with your buyer's lender to make sure you don't go over the maximum usable amount. Keep in mind that creative lenders can be pretty creative and can make the reason the language says what it says. The reason it doesn't just say closing cost credit or lender closing costs and says lender permitted closing costs and other prepaid items is the prepaids give the lender a lot more latitude. Prepaids can include things like funding the escrow account, which depending on the price range of the property, that alone can consume thousands of dollars, notwithstanding the fact that the buyer is also crediting the seller, the seller is crediting the buyer for the real estate taxes accrued up to the date of closing, which is offsetting closing costs. So even though the seller is already providing that credit, you can have third-party funds that are going in to fund the escrow account, which can be a point. So funding the escrow, insurance, those are good. And then the buyer's attorney fee is another one of the items that can be done as well. Okay, so there's an escrow option. Not going to be used real often because it creates its own hassles in many cases, but with lenders. But deposit at closing in escrow the sum of X to be held for payment for repairs pursuant to the terms of a separate agreement to be entered into hereafter between the parties. Any remaining balance of such funds after the escrow requirements are satisfied shall become the property of the sellers. In other words, it's the seller's money being impounded, and if that money, once impounded, is not used for the specified purpose, it is therefore going to go back to the sellers. No price reduction, credit, or escrow provision. In other words, we're going to officially have a post-inspection agreement so that the contract doesn't terminate, and we're agreeing we're not doing anything. If the parties agree that one of the attorneys is going to hang on to an escrow, that's fine. But always make sure you run by the attorney, do I need to send this to the lender? Because here's what happens in the world of lenders. The originator, who's going to be our contact person, because I've had it happening this week, and I'm amazed how often it's happened. In fact, Tracy's heard me end a couple of phone calls, and as soon as the phone was hung up, I punctuated the conversation with, and thank you, but I will not be committing mortgage fraud with you this week. Well, that was a loan originator, where the originator is paid to get the loan out the door. And the originator will not uncommonly, and these are not necessarily people that are proposing something evil. They are proposing something for which they won't end up in federal prison, but you will. And that is, we're going to suggest that you do this outside of closing, keep it off of our radar screen, which means we keep it off the underwriter's radar screen. So you're going to do this, and if you ever do get caught, I am never going to cop to having told you to do that. And so I'm going to be out of the line of fire, but you will have been one of the realtors guiding the parties to this illicit side deal when the closing has a document that promises there are no side deals. So to answer the question that was just asked, if you're going to do an escrow and one of the attorneys says, I'm going to set it up, I'm going to hold the funds in my trust account, no problem, be sure you're asking your attorney, do we need to update the lender? Now, because you don't want to go asking the lender necessarily, because they're always going to say, hey, do you want a copy of that radon test? Do you want a copy of that inspection report that talks about the termite ravaged sagging floor joist? So check with your attorney. You want the cover of having checked with the attorney and not looking like you were unilaterally making a judgment call that could be construed as being complicit with mortgage fraud. Here's the deal. Part of the purchase price was including the value of the seller in consideration of that purchase price being received, agreeing in a side agreement that they weren't sharing with the lender that we're going to let a certain obligation survive closing, and we're going to pay with a personal check outside of closing for something that's really tied into the closing. And so that's where you want to make sure you don't ever have anything that's off the attorney's radar screen. Let the attorney tell you if you're going to be selectively sharing items with the lender. And I want to make sure that doesn't sound like we're trying to decide exactly how much fraud we're okay committing. We all know that underwriters' job, and in fact recreation, seems to be trying to stop deals in their tracks. And if you put yourself in their shoes, they're not in the field, they're just seeing what's on paper, and they always have to make worst case scenario assumptions. They're all taking a CYA attitude. Let your attorneys say, I am comfortable from an overall lending standpoint not sending this to the lender, or it does need to be sent to the lender. So what you're talking about is a workaround, but it could still invoke this issue of the lender's position is, so the collateral as of closing has a defect that's being allowed to stay there, and the purchase price is being inflated, so some side deal can involve checks being written outside of closing. Any portion, going to A here, any portion of the subparagraph 2, credit above, which exceeds the amount permitted by buyer's lender, shall be deducted from the purchase price to yield a reduced purchase price, but only to the extent that such a reduction in purchase price does not require the closing to be delayed. Let me explain. If you overshoot in the post-inspection closing cost credit, post-inspection closing cost credit only, this then specifies that you don't end up with the Price is Right showcase showdown risk of I overbid and therefore I lose it all. In this case, you overbid and it's only the overage that can then be applied to the purchase price as a reduction. But only the extent that such a reduction in purchase price does not require the closing to be delayed. So you could still forfeit some of the credit that you've negotiated if you did not consult with your lender and confirm that every penny of that could be used in closing costs and prepaid credits. Okay? And in the initial contract, If you're not using this form, if it's just a closing cost credit baked in on the initial offer, there is no provision for alternate use of the closing cost credit. If it gets chopped down by the lender, you have just lost that money. And so if you bargain for $2,500 and the lender says we can only use $1,200, you've just lost the $1,300 difference for your buyer. Okay? So be aware of that. And I would encourage, on a related subject, everyone should have that conversation with their buyers. Unless it is something that is really newsworthy, earth-shattering, something we couldn't have seen without an expert set of eyeballs, and something that is, furthermore, fundamentally inconsistent with our overall expectations for this type of property, i.e. a 40-year-old house or a 100-year-old house, then you should consider that as part of the as-is. I looked at the house with my own eyeballs. I familiarized myself with its condition. So parties hereby agree. Hereby agree. So you have not an initial express lane termination, because we have that option as well. It's we've made requests, we've negotiated, we've had back and forth. It's just not going to happen, and so we're mutually agreeing for cancellation of the contract. I know we really need to brand these. We need to come up with some snazzier names, because here is express lane cancellation. That is the bam, we don't want it, and there's nothing you can do about it. And you don't have to sign anything, Mr. and Mrs. Seller, because we're serving this unilaterally and we're out. And that's it. And furthermore, previous provision of the contract, you promised you would expediently get that earnest money, or expeditiously, I guess, get that earnest money refunded to us. Not pass go, not collect $200, and we're suing you, and you're paying our attorney's costs if you delay. So that's the express lane termination. Withdrawal of notice, this is the, oh, how foolish I have been. I'm sorry, I take it all back. Now, note that that's qualified. Withdrawal of notice must be served upon sellers no later than the agreement deadline specified in 5D, meaning to avail yourself of that option, you have to do it no later than the second deadline in the inspection contingency. So, as always, you serve your notice by the first deadline, the notice deadline, and if you're going to have the change of heart, I take it all back, you must do that prior to the second deadline. And because that's under deadline, if you're availing yourself of that option, it's probably because your buyer's had an oh crap moment. I screwed up and I'm about to lose the house that I really want, and it may be because the sellers have someone else they want to sell it to. You better darn well make sure you serve the notice via certified mail and have that receipt. So we go back into another scenario where following the letter of the notices paragraph becomes very crucial, because you will need to prove that that withdrawal was done according to the time frame specified. Does that all make sense? So that gets us through everything I intended to cover today, and we did it in under the 90 minutes. I knew this was not going to be an hour-long Legal Thursday. Thank you all for being here. I will hang around and answer any questions you have. Go forth and enjoy your updated contract, because I have slaved over it for 7 years.